Hello, everyone. My name is Taylor Frank, and I'm an attorney with the Alaska Legal Services Corporation. Our video today is a general overview of the eviction process in Alaska, including what can trigger an eviction, the eviction hearing, and some other matters. This is a basic overview and should be a helpful guide should you find yourself either facing eviction or needing to evict somebody. A little bit about ALSC. We were established in 1967 as a private nonprofit law firm. We provide free legal services to eligible clients as determined by their income eligibility and case eligibility. And this has enabled about 6,400 low-income Alaskans to address critical civil legal issues. We have 12 offices that collectively serve every community in Alaska, and we assist clients facing a wide range of issues from consumer law to family law, housing problems, public benefits, healthcare, Alaska Native law, and other areas specific to veterans and the elderly. Today, what we're going to be talking about is a basic overview of the eviction process, including what can trigger an eviction, forcible entry and detainer hearings, which is the eviction hearing itself, and common defenses that you can see in eviction hearings. So the eviction process, what is an eviction? An eviction is an action to recover possession of a rented premises. The notice of eviction is called a notice to quit. And the eviction action itself that's filed in court is called the forcible entry and detainer action. Basically, it's the process of removing a tenant from a rented premises by the owner of that premises. The timeline for how an eviction goes forward is pretty straightforward. First, the tenant receives the notice to quit. This must be delivered to the tenant in person, left at the premises, or sent by registered mail. Next, the tenant fails to remedy the issue if applicable, which we will talk more about in a bit. And next, the tenant fails to vacate the property. After that, the landlord will likely file the FED complaint. This cannot be sent by mail. This must be done via process server. After that comes the FED hearing. It is just like any other hearing. The landlord will present their argument and then the tenant gets to defend against the charges. If evicted, the judge will decide how long the tenant has to vacate the property, which is usually a few days. And if the tenant does not vacate, the landlord may seek a writ of assistance from the court, which will allow police to physically remove a tenant from the property. The notice to quit is a notice from the landlord to the tenant giving the reason for eviction. It is not a complaint with the court, that is the FED filing. And there are several different kinds, which will be covered in depth in another video. Grounds for eviction. For a periodic and holdover tenant, it can be any or no non-discriminatory reason. For a week-to-week tenant, that is a 14-day notice. For month-to-month tenant, it's a 30-day notice, and this notice is calculated from the next rent due date. So if rent is due on the 1st of every month and the landlord delivers a 30-day notice to quit on May 5th, the tenant has until July 1st to vacate. When you have a written lease, there are two separate grounds for eviction. There are curable grounds and there are incurable grounds. Let's go over curable grounds first. There is non-payment of rent, in which you must vacate the property within 10 days or cure within 7 days, so pay the rent within 7 days. Next is material non-compliance with the rental agreement, so breaking your lease. This is also vacate within 10 days or cure within 7. And then there's failure to pay for a utility service. This one you must cure within 3 days or vacate within 5. And you must pay for the utility and repay the landlord for any amount paid to reinstate the service. And if any damage occurred, there is no opportunity to cure. The last bucket for curable grounds for eviction is non-compliance with the Uniform Residential Landlord Tenant Act. These include 10 different grounds, the first being failure to keep a clean and safe premises, then failure to dispose of trash, failure to keep plumbing fixtures clean, failure to use the premises in a reasonable manner, making deliberate or negligent destruction or allowing someone else to do so, disturbing a neighbor's peaceful enjoyment, Failure to maintain smoke and carbon monoxide detectors, changing locks without permission except within an emergency, and in an emergency, you must provide the landlord with new keys within 5 days. There's being a nuisance on the property, which basically means if the police get called to your residence 3 times, the landlord will get fined unless they evict you. There are caveats and exceptions to this, but that's the basic idea of it. And finally, housing more people than allowed by the law or by the lease. Next, for incurable grounds. The first bucket is illegal activities. This is not just any illegal activity, but it must be one of the following, and it's a 5-day incurable notice. If you use the premise as a place of prostitution, conduct illegal activity involving alcoholic beverages, gambling or promoting gambling, controlled substances or imitation controlled substances, or knowingly permit another to engage on the premises in those activities. The next bucket is intentional substantial damage. And Alaska defines substantial damage as in excess of $400. And if the landlord delivers a notice to quit for intentional substantial damage, the notice is a 24-hour notice. And finally, if you commit the same curable violation within 6 months, you have a 5-day notice to quit. The only exception is if you fail to pay for utilities twice within the same 6 months, you have a 3-day notice to quit. Mobile homes are treated slightly differently, and they have a slightly more protection than ordinary tenants. You can only evict for non-payment of rent, a violation of the law where the continuing violation is detrimental to the health, safety, or welfare of other tenants. So for example, a court has found that shooting a gun through another's window and children stealing property is detrimental to the health and safety of welfare, but a dog scratching at the door or a junk car in violation of the lease is not detrimental to the health, safety, and welfare of other tenants. Next, for violation of the rental agreement. And finally, if there is a change in the use of land for the mobile park, but this must be a 270-day notice, and it cannot be during winter. It must be between the months of May and October. After the notice to quit comes the forcible entry and detainer complaint. So when a tenant fails or refuses to remedy the breach or deliver possession within the days specified in the notice to quit, the landlord will file an eviction action. The action must be commenced after the date specified in the notice to quit in order to be valid, and the summons must be delivered at least 2 days before the hearing. Courts can grant continuances, but not for longer than 2 days unless the defendant shows good cause and provides a surety for rent for the intervening days. Damages are in a separate hearing. The forcible entry and detainer first part is only for possession, and these will be covered in another video. So the timeline for forcible entry and detainer. First, tenant receives the notice to quit and fails to remedy. FED filed with the court. The landlord serves the FED. The FED hearing happens within 10 days, and if evicted, the court will order the tenant to move out. Again, usually within a few days, though during COVID, we have seen this time be a little bit longer. At the hearing, as stated before, the landlord will present their case and the tenant will present their defenses. Damages and counterclaims, again, are not discussed. This is done at a future hearing. And at these hearings, the court often serves as sort of a mediator and will try to resolve the issue without having to order an eviction, so as to keep the tenant's record as clean as possible and hopefully allow them to find more housing in the future. Some common defenses that we see, first and foremost, is a defective notice. This is the most common defense, as strict compliance is necessary, as determined by the Alaska Supreme Court in Taylor v. Gill Street Investments. This will be covered in depth in another video. Next, we have waiver of the right to terminate. So if the landlord accepts rent with knowledge of default in the rent, or accepts rent when performance of the tenant varies from the terms of the rental agreement, the landlord has waived the right to terminate the rental agreement for that breach. So for example, if a rental agreement prohibits dogs, but the landlord has been accepting rent from tenants with knowledge that they keep dogs in their unit, the landlord cannot evict those tenants because those tenants have dogs. And the last common one is a factual defense. So the tenant did pay the rent. The tenant did comply with the rental agreement. The tenant cured within the proper time. The tenant did not engage in illegal activity. The tenant did not commit intentional damage. This is a fairly easy thing to prove. The tenant the landlord must prove that the tenant both caused damage intentionally and that it was substantial, so that it was more than $400. It's very difficult for a landlord to prove both prongs. And importantly, the burden of proof in these matters is always on the landlord. Finally, the Alaska Landlord-Tenant Act provides that attorney's fees can be allowed to the prevailing party in any proceeding arising out of this chapter. So whether it's the landlord or the tenant who is able to prevail in the proceeding, they can seek attorney's fees from the other side. If you have any questions or anything that you would like to add, please don't hesitate to contact me. My contact information is on the screen. You can reach me via email at tfrank@alsc-law.org or via telephone at 907-222-4517. Thank you.